Mr. McLeod, Pereira seems to work against you. So I think it would be good for you to spend a bit of time on that.
Certainly, Your Honor. So I think that the important thing about Pereira is that it was a narrow decision that decided a particular question presented. And that question presented was about the interaction between the stop time rule in 1229 BD1 and the notice to appear requirements. And if I could point to where in the court's opinion that holding appears, it's at the beginning of Part 2B of the opinion. This is on page 2114 of the Supreme Court Reporter version, if you have that available. And at the beginning of the first paragraph of that section of the opinion, the court says, the statutory text alone is enough to resolve this case. It then proceeds to analyze the text of the two provisions that I just referenced. Now, it's true that after this point in the opinion, there is additional analysis, but I think much of that additional analysis is dicta. The court said that that analysis supported or bolstered or reinforced the conclusion it had already reached. And I think that's particularly true of the statements that the non-citizens and the Ninth Circuit have relied on in Pereira. To go directly to the statement about the meaning of change, the meaning of change was not briefed in Pereira, was not argued in Pereira, and so the court in Pereira did not have before it the wealth of argument and evidence that we have brought to bear on that question in this case.
I take the point, Mr. McLeod, but, you know, it is a very direct statement. By allowing for a change or postponement to a new time or place, Paragraph 2 presumes that the government has already served an NTA that specified a time and place as required by A1. And I don't think we were looking to reach out and decide a lot of questions that weren't before us. I think, and this was 8 justices joined this opinion, it just seemed this sort of obvious understanding of the statutory scheme. So, even if it's dicta, it reflected what 8 people thought was pretty obvious when you looked at the statute.
So, Justice Kagan, if I can take that in 2 pieces. So there are 2 sentences there. The first one you referred to talks about a presumption in the statute that the notice of hearing will follow the notice to appear. And I agree. I don't think that there is any dispute that there is such a presumption in the statute. But identifying that presumption does not answer the question in this case, which is what happens when the presumption is not met and the notice to appear did not contain the time and place information. Then the second statement, which I acknowledge is a difficult statement for me, is the statement about the meaning of change. And I do think that's dicta. I also think it's incorrect dicta. And it's not surprising the court got that incorrect because it just did not have the evidence, like the dictionary definitions, like the contextual evidence about the meaning of change that we have brought to the court's attention in our briefing in this
case. Mr. McLeod, that seems to beg the question. The finding in that case, and since I wrote it, was that the statutory presumption commanded by Congress, who knew full well that the government was giving notices with TBAs, time and place to be announced regularly, was contrary to that history. They wanted these notices to be full and complete. That's what we held. And having held that, I think there's a presumption that you have to look at the statute in that context, that there will always start with a proper notice to appear, and if you're going to change the time and place, you're going to give a new time and place. I don't understand that a new time and place is something different than what you've already specified.
And Justice Sotomayor, in this case, we think that we did satisfy that burden because we did provide a new time and place. We told the non-citizens where their removal hearings would be held, and so they had the information they needed to attend. And so I don't think that change is actually the operative word in the statutory scheme, but I don't want to fight you too hard on that because I do think that even if you think that notice of hearing must change a previously set time or place for the hearing, that requirement is satisfied here because the ordinary meaning of the word change is very broad, and it encompasses the process of going from—
So change is no change, meaning you haven't set a time and place, and we're going to change that and set what, another no time and place?
Your Honor, what we have done—
No, it's going to be a time and place now.
Your Honor, what we have done in the TB NTAs is to tell the non-citizen you are going to have a hearing. We don't know when that hearing will be, but we have changed from that placeholder time to a specific time. And we think that under the ordinary meaning of change, particularly as it's used in this statutory scheme, going from an indeterminate time and place to a determined one is a kind of change.
Mr.
Mr. McLeod,
Sorry.
didn't you lose that argument in Campos-Chaves? I mean, I understand and take your point, but I thought the court said you really couldn't interpret the statute in that way or the word change in that way.
Respectfully, Justice Jackson, I don't agree. I think the only issue that the court decided in Campos-Chaves was whether we could compile two documents together to create a notice to appear, and the court said that that definite Article A indicated that the notice to appear needed to be a single document. And so we are not disputing for purposes of these cases that the notices to appear alone could not be the basis for in absentia removal. But what's critical about this case and what distinguishes this case from Pereira and Campos-Chaves is that Congress here created two forms of notice, and it made both of them relevant for purpose of in absentia removal in a way that they are not relevant for purposes
Can you say more about that, two forms of notice? What do you mean?
I mean that they created both the paragraph 1 notice, the notice to appear, and the paragraph 2 notice, the notice of hearing, or as the other side refers to it, the notice of change.
So you think those operate completely independently of one another?
They're independent in the sense that they can both be independent, valid bases for in absentia removal. I take the point that the notice to appear is what initiates the proceeding, and so some sense you need to have a proceeding in order for there to be a notice of hearing to alter that proceeding. But I don't think it is the case that the TBD status of the notice to appear in any way invalidates the later notice of hearing. And that's because the statute is very clear about the requirements for a valid notice of hearing. It needs to set the new time and place, and we did that in this case.
Mr. McLeod,